This is Michael Popok with a Legal AF Hot Take. It's time to talk about Judge Scott McAfee and his recent ruling against Donald Trump and others, finding that he would not dismiss the indictment against Donald Trump in Georgia for election interference and racketeering conspiracy. At least at the present, he won't dismiss the indictment on First Amendment grounds, which is a primary attack by Donald Trump and his lawyer Steve Sadow against the indictment. But I want to really dive into it here on this hot take and tell you what I think happens next and on the impact of the ability for Fani Willis, the Fulton County DA, to get a trial up and running before November, because I think it's becoming increasingly more unlikely that there's going to be a Georgia trial before the November election. And I'll tell you why based on what I found in this particular ruling. So the headline, and then I'll get behind the headline. In a 14-page ruling, Scott McAfee, as expected, as we predicted, rejected the First Amendment defense argument in which Donald Trump's lawyer, Steve Sadow, argued that all his client is being charged with boils down at its essence to core political campaign speech that can't be criminalized because the prosecutor or the grand jury doesn't like the content of that speech. It's what's called an as-applied First Amendment challenge. Now, in order for the judge to assess that defense at this moment, at the indictment stage, he has to apply a standard in which all of the allegations of the indictment are assumed to be true, meaning that the burden is on the Trump in this case to demonstrate that even under the true allegations of the indictment, that somehow the First Amendment would give him protection. So in this kind of analysis, the prosecutor is given an advantage because at the indictment stage, everything in the indictment is assumed to be true. So that's where we start from. Steve Sadow made a lot of statements in oral argument. They were all reported live because Judge McAfee uses YouTube for all of his hearings. And you saw Steve Sadow time and time again refer to core political speech, that all Donald Trump is being accused of is making comments that people don't like or find to be in bad taste or find to be against their own political views, and he can't be indicted for that. And what the judge said, following now in a long line of judges on these very issues, starting with Judge Chutkan, the federal judge in the D.C. election interference case, as affirmed by the Court of Appeals, the D.C. Court of Appeals, three-judge panel, is that there are, of course, limits to First Amendment protection for speech. Not all speech implicates First Amendment principles, particularly there is no First Amendment protection for speech that is used in furtherance of a crime or is the crime itself. I mean, in order to communicate among co-conspirators, as alleged in the Georgia election interference case, for instance, they had to use speech, whether it be in writing or orally. And so Donald Trump's argument is that, well, yeah, he talked about trying to overthrow the will of the people, but that's just First Amendment expression. That's just his opinion. But no, it went further because, as alleged in the indictment, he did it with willful criminal intent, what we call criminal mind or mens rea. And that's for a jury to decide. I mean, even McAfee in his 14-page decision said that issue as to whether the speech was used in furtherance of a crime or was a crime itself, lobbying election and elected officials to overturn the will of the people, to throw out ballots, to use or recognize fake elector certificates, trying to interfere with the vote count itself, trying to get the Georgia Senate to conduct hearings when there was no plausible proof of any outcome determinative fraud. That, as Judge McAfee recognized, as alleged in the indictment, that is speech in furtherance of a crime or a conspiracy or an attempt to deceive the government. And that is the very heart of the indictment. Now, look, let me just take a quick break here in the hot take to tell you, kind of speed to the end, and I'll read from certain sections of the order in a second. The judge basically denied the motion to dismiss, meaning he's not going to dismiss the indictment, but it's without prejudice, meaning he's allowing the defendants to raise this issue again after the factual record is developed at trial. I mean, that was one of the arguments Steve Sadow made, and he had a little bit of a debate with the judge on this issue, which was, we don't want to wait till trial, Judge. We want to have you make the decision right now on a limited record. And the judge says, well, listen, I got to do the indictment, and I have to assume all the facts in the indictment is true. And there aren't many other developed facts in this case. But he allowed it to be raised, and I'll read to you where in the very end of the order the judge says you can raise this issue again after a factual record has been developed, and that means generally means at trial, and that's how Sadow and Trump are interpreting it based on their public statements after this decision, which they no doubt will appeal, and we'll talk about the delay that this will have impact on the delay of the trial as well. But let me get into the order because the good news is the indictment is not dismissed. That Fani Willis, Fulton County DA, has an indictment that has survived multiple challenges. Now, there are other motions to dismiss out there that still haven't been ruled on, and we'll get to that in a minute. But let's just stay right here in the moment with this particular order. Now, Judge McAfee in the 14-page order starts with framing the issue at the very beginning. He says on page 1 that the defendants argue that this prosecution violates First Amendment's protections of political speech and activity, freedom of association, and the right to petition Congress as applied to their alleged conduct, and further contend the indictment is overbroad. So there's the judge in the very beginning setting the table for how he's going to make his ruling. He then analyzes the First Amendment. So starting on page 2, he says, the First Amendment is a broad umbrella that shelters all political points of view and shields a wide range of avenues for expression. But he goes on to say that free speech, including political speech, is not without restriction. Remember, again, McAfee has the benefit and is standing on the shoulders of Judge Chutkan's ruling, similarly saying the First Amendment doesn't apply to the indicted conduct of Donald Trump. And the appellate court, federal appellate court, well-respected D.C. Court of Appeals, affirming Judge Chutkan's decision. So he's got that going for him, although he cites more to Georgia law and other Supreme Court cases than he does to the D.C. case itself, which is interesting. He says particularly that the First Amendment excludes from protection. Excluded categories, is on page 2, includes speech integral to criminal conduct, fraud, or speech presenting an imminent threat that the government can prevent, citing a United States Supreme Court case called Alvarez. Restrictions on speech integral to criminal conduct have never been thought to raise any constitutional problems, citing to another Supreme Court case called U.S. versus Stevens. And he goes on to say that nor is a false statement which threatens to deceive and harm the government that is knowingly and willfully made, that means with criminal intent, in a manner within a government agency's jurisdiction is free from restriction or First Amendment challenge. So now he's setting the table for himself about what toolbox of case law he's going to use to apply to the arguments raised by Donald Trump. He then lays out what he sees as the allegations of the indictment and reminds everybody, which is also important here, I believe, about what has been charged. And so on page 6 of 14, the judge says that the indictment, which he has to assume is true, alleges that defendants Giuliani, Smith, and Shealy knowingly and willfully made false statements to members of the Georgia Senate at a Senate Judiciary Subcommittee meeting, that the defendants, all of them including Trump, knowingly and willfully made and used a false document and conspired to knowingly and willfully file false documents purporting to certify 2020 presidential votes of the electors from Georgia, and falsely represented that defendants were chairman and secretary of a Georgia Electoral College meeting, that the defendants, that includes Trump, mailed with intent to file a false certificate of the votes of the 2020 electors, and record that false document, that defendants Trump and Eastman knowingly filed a document containing false statements concerning the election in a lawsuit in the United States District Court for the Northern District of Georgia, that covers Atlanta, that the defendants conspired to commit solicitation of false statements and writings involving an election worker, that's Ruby Freeman, and that defendant Schaefer, that's the former chairman of the GOP in Georgia, knowingly and willfully made false statements in the presence of the Fulton County DA's investigators. And that all taken together is part and parcel of the conspiracy. And then the judge goes on when he's going to now dismiss this, and I'll get to the sort of the heart of this, is after finding that as on the current record, assuming all the facts of the indictment to be true, he's not going to apply a First Amendment as applied challenge to dismiss the indictment at the indictment stage. He does say in his conclusion, let's go on to page 14, that without foreclosing the ability to raise similar as-applied challenges at the appropriate time after the establishment of a factual record, the defendant's motion based on First Amendment grounds are denied. You always have to get, behind the headline. Judge McAfee denies the motion to dismiss the indictment, and then there's a cheer that goes up. But there's a cautious cheer, because the judge is allowing them to try to convince the jury that all Donald Trump was doing was using his First Amendment rights. And that leaves open the door that the judge could allow a defense of some sort of freedom of speech defense with a jury instruction to the jury that could lead to an advantage for Donald Trump. And that's what we're worried about here, and that's what we're going to follow. It's, we'll compare it to what's going on with Aileen Cannon, the federal judge in Mar-a-Lago, where she's also at this moment struggling with jury instructions which demonstrate that she has a misapprehension and misunderstanding, intentional or otherwise, of the primary law in the case in Mar-a-Lago, the Espionage Act that's been charged, obstruction of justice that's been charged, and her view that perhaps the Presidential Records Act, that Donald Trump was able to magically convert nuclear codes and nuclear secrets of our allies and enemies into personal papers, that has infected her decision-making, and we may see it in the jury instructions, which could give an advantage to Donald Trump, especially if he's tried with the wrong jury instruction and the jury acquits him, which would lead to double jeopardy. He would not be able to be tried again, and there's no appeal related to that. And that is a double jeopardy problem that we need to keep an eye on as these very young judges, Judge Cannon being on the bench for about a year, mainly through COVID, when she got assigned the Trump case. Judge McAfee, brand new judge in his early 30s, similarly, also never tried a case before, handling these cases. And as they struggle with fundamental application of constitutional principles and law to jury instructions, it creates the possibility that we need to monitor, as that they'll set up a trap for the prosecution that could lead to the acquittal of Donald Trump and his inability to be retried by the prosecution, even after appeal under a doctrine we call double jeopardy. So we'll continue to cover all of this on the MeidasTouch Network and on Legal AF. We do it on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this YouTube channel, and then on audio podcast platforms of your choice. If you like this kind of content that sits at the intersection of law and politics, given by lawyers who know what they're talking about at that intersection, you've come to the right place. MeidasTouch Network and Legal AF. And if you want a deeper dive, even deeper to the molecular level of the law, federal, state, criminal, civil, procedural, constitutional, civil rights, and the like, you're going to love our new Patreon. We have exclusive content there you won't find anywhere else. It's at patreon.com/legalaf. You'll see new kind of instructional TED Talk-like videos every week. Only one place, MeidasTouch Network and patreon.com/legalaf. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.